In this video, I'm speaking with Kristen Lewis about special needs estate planning for people with disabilities. Ms. Lewis is a nationally recognized for her proficiency in special needs trust planning for persons challenged by disabilities and is a frequent speaker on this topic. Kristen, thanks for coming on and sharing with us.
It's my pleasure.
Yeah, I know you're passionate about this topic. So let's start at a high level. What are the primary goals of special needs estate planning for persons with disabilities?
So, when we represent families that have a child or another loved one with a disability in the context of their estate planning, one of the primary goals is to preserve their loved one's eligibility for any means tested government programs or benefits that they might be eligible for as a consequence of their disability. And so we want to make sure that their private wealth and resources supplement whatever the government programs don't pay for. And of course, government programs pay for some things, but they don't pay for most things. Another thing that especially families of means find to be very surprising is that many of the beneficial programs and services they want for their child or other loved one with a disability are literally not available on a private pay basis. So these wealthy families who are used to having their private resources afford them access to whatever they want for their child or other loved one with a disability are shocked to find out that literally private pay is not an option. And so for many families, the government benefits element of the planning that they do for their child or loved one is a matter of access to these beneficial programs and services that they cannot obtain on a private pay basis and that require eligibility for SSI and Medicaid. So those are very important goals of special needs estate planning that are not present in the more traditional estate planning that Kim Davis discussed.
Yeah, so, Kristen, clearly there needs to be a comprehensive approach to this. And so, what is the foundation of a comprehensive special needs estate plan?
When I have a prospective client or an attorney that wants to co-counsel with me, and they say we're dealing with a child or another loved one with a disability, so we know that we need a special needs trust. Can you draft a special needs trust for us? I know that they have not even scratched the surface if they think that a special needs trust is all that the family requires. So, the foundation of a comprehensive special needs estate plan is not a special needs trust, but rather a network of multiple special needs trusts, each of which is designed to be funded with different assets at different times and many times from different people. And so every family's network of special needs trust is slightly different, but it derives largely from the kind of assets that families have to set apart to secure the financial future of their loved one with a disability. So in my practice, just about every family has an IRA or a 401k, some sort of retirement plan that they want their loved one with the disability to be able to participate in. So if that is the case, one in the network of special needs trust is a third party special needs trust that is designed for the sole and exclusive purpose of receiving required minimum distributions from an inherited IRA, 401k, etc. Not every special needs trust qualifies under the Internal Revenue Code and the Treasury regulations. And now, since January 1st of 2020, the so-called Secure Act. And so there are many limitations imposed by the Internal Revenue Code, Treasury regulations, and the Secure Act that we do not want to be bound by in the context of other third-party trusts. So if families have a bunch of life insurance, which is a very, very common way of funding the network of special needs trust, we would use a slightly different third-party special needs trust. Most of our families have collateral relatives, Aunt Jane or Grandma Dorothy, who want to help secure the future of the individual with the disability. And so if that is the case, I include in the network of special needs trust what I call a receptacle third-party special needs trust that is designed for the sole purpose of coordinating the well-intentioned generosity of these other family members. Sometimes there are friends, you never know, who might want to help secure the future of the individual. So we try and make it as easy as possible for these generous third-party donors not to blow up the entire special needs estate plan by their well-intentioned generosity. Other trusts that are in the network would be either a testamentary third-party special needs trust under the will or the funded revocable living trust of the parents, typically. And then we always include at least one first-party special needs trust in the network, which is designed to hold assets that the beneficiary already owns, but would stand in the way of eligibility for these means-tested benefits, or assets to which the beneficiary becomes legally entitled in the future, notwithstanding our best efforts to make sure that doesn't happen.
Kristen, it's clearly very complex. This isn't something that a family should go and try and execute on using a Google search and and their friends. You need to hire a professional to have this mapped out properly.
So this is one of those areas that you cannot fake it. You either need to be all in and you do this for your legal career or not in it at all, because the consequences of not doing it right are catastrophic and often result in the loss of these very valuable means-tested government benefits. I'd say probably 30% of what we do in our practice is fix the mistakes of other lawyers who either know nothing about special needs estate planning or just enough to be dangerous.
Hmm. So let's shift gears just a little bit, Kristen. How can a family use planned giving techniques in the context of special needs estate planning?
Securing the financial future of an individual with a disability involves coming up with a funding formula to make sure that both the present and future needs are covered. And most families have multiple sources of funding. I've already alluded to a couple of them. Retirement accounts, life insurance. But for those families that are philanthropically inclined, let's say their child was well served and is continued to be well served by CVI, and the child has a visual impairment or blindness, it is possible to designate one of the third-party special needs trust in the network that we talked about as the income beneficiary of a charitable remainder trust, as long as that charitable remainder trust has a fixed term that does not exceed 20 years. And I'm pretty sure that Kim Davis talked about charitable remainder trust as one of the tools that plan giving departments have at their disposal. And so, for families who do want to support and in gratitude, a charity that has played a role in the life of their family, supporting their loved one with a disability, that can be another source of funding for that person's needs. Um, every once in a while, we have a situation where a family believes that their child's share of an estate is actually overfunded and that that individual is not going to need all of the resources and assets that have been earmarked for him or her. In a situation like that, many times a charity is the recipient of a lifetime gift or a testamentary bequest. Many times we will be listing charities as default takers if the person with the disability does not survive, for example, under the estate plan that we've put together for the parents of the individual with the disability. And so there are many ways to remember charities that have been supportive and helpful during the lifetime of an individual with a disability. And in fact, any of the third party special needs trusts that are in the network, you could designate the charity as the remainder beneficiary, not the same thing as a charitable remainder trust. But if and only if there are assets left in one or more of the third party special needs trust in the network, we often will designate a favorite charity of the family to receive whatever there is left.
So when you think through, if you this is new to you, you have to go and do research, connect with a professional who knows exactly what they're doing, and then you get the documents executed. How is a special needs estate plan actually implemented after the execution of those documents?
One thing that families tend to overlook is that a special needs estate plan is not self implementing. And after all of the legal documentation has been executed, part of our work together involves identifying what I call the team of allied professionals. And these are the individuals who will make sure that the plan, the special needs estate plan that we have designed for a family, actually gets implemented. And one of the very first team members that I refer my families to is a government benefit consultant that will make sure that their loved one is tapped into all the different programs and services that they are eligible for as a consequence of their disabling condition. And then if there are some that they haven't tapped into, will actually help apply for those benefits. Another important member of the team is a life care planner. One of the scariest things about having a child or other loved one with a disability is not knowing how to answer the question, how much is enough to fund this network of special needs trusts that we have put in place, ready to be funded after our demise with life insurance or an inherited IRA and so forth. So a life care planner develops what's called a life care plan. And that is an important tool that is an objective, arm's length assessment of that very answer. How much is enough to fund what the child needs? Many families whose child has a disability that's nobody's fault, they have never heard of a life care planner. And so, a really important part of my job is connecting families who don't have a life care plan with a professional that can prepare that for them. Another important member of the team of allied professionals is a life insurance professional. Vast amounts of life insurance are typically required to fully fund the life care plan that is developed for an individual with a disability. And many times, in addition to insuring the parents, typically of a child with a disability, that individual with the disability needs to get insurance on their life. They may have a disability, but it might not affect their insurability for life insurance purposes. And many of our beneficiaries go on to have pretty neurotypical lives. They have a spouse, they have children. And the responsible thing to do is to provide for the spouse and children of a person with a disability. And life insurance is an important aspect of their own personal planning. And then the final team member, these allied professionals, is an investment professional who understands how a person's disability may affect their life expectancy, may affect, a cash flow analysis, and of course, their risk tolerance. As a general matter, people with disabilities tend to be pretty risk averse when it comes to investing whatever funds have been set aside for their benefit by family members and other friends. So, an important part of my role as a special needs estate planning attorney is to connect my families with these allied professionals and be able to vouch for them that they actually know what they're doing and are not trying to fake it.
Kristen, that's incredible. Like, you have to have a team to execute on this type of program for somebody who has special needs. Special needs estate plans fail, unfortunately. What are some of the major reasons as to why they fail so people can think ahead?
The number one reason why the perfect special needs estate plan fails is a poor choice of trustee of the individual's network of special needs trust. And many times, if a family does not meet the very high minimum of many professional trustees, they end up with a list of trusted and well intentioned individuals who are not professional trustees and who basically don't have a clue what they're doing and are not willing to ask for help from the team of allied professionals that we have assembled to facilitate implementing the plan correctly. Many times, if the beneficiary with the disability is not going to have a spouse or children, and the neurotypical siblings of the beneficiary are designated as the remainder men of this network of special needs trust. If those remainder beneficiaries are serving as trustee, they are holding the purse strings of a fund that they stand to inherit when the beneficiary with the disability passes away. That is a conflict of interest that generally cannot be overcome. And many times, the parents, typically of the beneficiary with the disability and the neurotypical child who they want to be the trustee, they are in total denial about that conflict of interest. And the last thing I want to do is set up a special needs estate plan that puts a neurotypical sibling in that conflict of interest position. Human nature being what it is, we do not want the trustee slash remainder beneficiary to skimp on distributions for the beneficiary with the disability, hoping to assure a larger fund for themselves when the beneficiary passes away. So, and then the final reason is, again, failure to consult with the team of allied professionals, each of which is on the team for a different reason. And the trustee has their particular job. All these other team members are just ready and waiting to collaborate with the trustee to make sure the plan works the way it's supposed to.
Well, Kristen, I appreciate your time. This has been very informative. Where could viewers learn more about your practice?
Well, so I am currently practicing at the Bowden Law Firm in Atlanta, Georgia, and there are a lot of materials that we have posted to my attorney webpage and are freely downloadable. Part of my professional mission is to educate families before they even call us or step in our offices. And so hopefully those would be excellent resources for people who either know that they have to do special needs estate planning or kind of on the fence about whether they should dive in and do it.
Excellent. To learn more about the Center for the Visually Impaired, visit cviga.org. That's cviga.org. Thank you.